On the record in the matter of the state of Michigan versus Zachary Wick, 25309. And Detective, your name for the record, please.
Chris Zabel, Your Honor. Good morning.
Good morning. Can you hear me okay?
Yes, ma'am.
Yeah, okay, please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth? Okay.
This courtroom just exploded with tension. A father accused of slapping his 13-year-old daughter, then brawling with his own brother after forcing entry into the home. Family torn apart, history of violence exposed. Stay locked in, because this story only gets darker. Subscribe now for more shocking courtroom breakdowns.
And Detective, if you may proceed on the warrant.
Thank you, Your Honor. On 3/9/2025 at approximately 9 p.m., the defendant, Zachary White, was drinking and got into an argument with his 13-year-old daughter, Layla, in which Zachary slapped her in the face or on the cheeks with an open hand. Jeremiah and Samantha were in their home's basement doing laundry when all of a sudden their daughter ran downstairs and advised them that Uncle Zachary slapped Kayla. Jeremiah and Samantha went upstairs and Jeremiah attempted to intervene. Zachary told him, which is his brother, that he was having a one-on-one talk with his daughter. Samantha got Kayla inside the house and Jeremy locked the door with Zachary outside of the home and told him to leave for the night. Zachary forced entry into the home and damaged the storm door and the inner hard door. The two brothers fought, ergo, the domestic violence won unto Jeremiah, brother and brother, who currently reside together. And prior to that, a DV on Kayla, father, daughter, with the additional note, a criminal history of a conviction for domestic violence.
All right, thank you. Upon examination of the complaining witness. Oh, I'm sorry, Detective, there's also a third offense notice?
Here's where the legal stakes rise. The judge highlights a third offense notice. That's not minor. It's a felony carrying serious prison time. Add prior convictions, and suddenly this isn't a family dispute. It's a high-risk repeat offender case. Viewers, do you think prior history should weigh heavily on bond decisions?
Third offense notice, yes, Your Honor, which is a 5-year felony with that prior conviction in 2023.
All right, upon examination of the complaining witness, I find that the offenses charged were committed and there's probable cause to believe the defendant committed those offenses. And counsel, your appearance, please.
Yes, Your Honor. John Goldport, P. 30758, on behalf of Mr. Week.
Thank you. And Mr. What? Your name for the record, please.
Zachary White.
White, I'm sorry. Recording. Counsel as to bond.
Your Honor, well, first of all,
I'm sorry, is the agreement?
Your Honor, it's my understanding that there is a third offense notice, thereby making this matter, I believe, felony. However, I raise this because it appears that there are two separate victims. I'm just making this for the record, with respect to the initial charge. One being the brother of Mr. Week, and who he resides with. And second of all, his daughter, the defendant's daughter, is my understanding.
Okay.
The prior conviction was approximately 2 years ago, is that correct?
No.
Oh, I'm sorry.
April of 24.
Oh, April of 24.
I'm showing that he pled guilty to domestic violence second offense.
Oh.
The felony, assault with a dangerous weapon, 2 counts, and another domestic violence second offense matters, those were dismissed. And then he started probation April 17th of 24 with the Third Circuit Court. Would that be accurate, sir?
Sorry?
Is that accurate? You're still currently on probation?
Yes, Your Honor.
That matter was out of Southgate, is that correct, Ron?
No, why not?
Oh, I'm sorry. I know he's
The
on.
Southgate matter from July was an OWI, well, operating while visibly impaired, also while he was on probation.
Because the way I was reading it, I didn't realize that it was a domestic violence second offense that he was on probation for.
Yes.
That would mean that he had one prior to that date. That's what
Minimum of one prior,
At the
correct?
minimum. That's what confused me when the only one that was cited for the third was just one offense. That's all. So with that said, Your Honor, we waive a formal reading of the charges. He would stand mute to the charges and ask that the plea of not guilty be entered.
The court will waive the formal reading. Counsel as to bond.
Your Honor, the court is well aware, this is not his first involvement with the criminal justice system. He is, as you've noted, presently on probation to this court, it appears. He's also, I believe, on probation into Southgate. Is that correct, sir?
That's correct.
He is gainfully employed. He's worked as a machinist for approximately 10 months. He is residing, or at least was residing with his brother at the Wyandotte address. We're asking for a bond. I'm sorry. We are asking for a bond which can be reasonable under the circumstances, understanding that he is on probation, both to this court and to other matters.
What are the current terms of your probation at the Third Circuit Court?
I'm seeking better counseling and with Motor City Center Pope for Lincoln Park, and for Southgate I'm with the Guidance Center. I'm in substance abuse counseling, regular mental health counseling, and I've been going to AA meetings, and I just started this new one with the Guidance Center. Everything was going pretty well. I'd like to continue and seek help with the issues I've been having. So, yeah.
Sir, you said that you were enrolling in batterers counseling. Did you already complete that?
I'm sorry, what did you say?
Your batterers counseling, did you complete that condition?
I'm currently doing it right now.
Well, why did it take you so long to start it, sir, since you've been on probation for nearly a year?
I go every Friday at 3:00.
You've been going
And,
every Friday?
I'm going for that. I'm going every Friday at 3:00, and for the substance abuse counseling, I'm going every Tuesday at 5. And I have AA meetings 3 times a week at 2:30 Saturdays and Sundays, and 7 p.m. on Wednesdays.
Okay, sir, when did you begin your batterers class?
Should I what?
When did you begin your batterers intervention class?
I got into that one January. I'm not sure what date.
Sir, I'm going to guess that you're not allowed to consume alcohol while you're on probation for either one of those, whether it's Third Circuit Court or 28th District Court in Southgate. Is that a good guess?
Yeah, that's correct.
Yeah. You are, with allegations of drinking again.
I know I have a problem.
Wait, did you catch that? The victims span across his entire family: daughter, brother, ex-wife, sister-in-law. This is a chilling pattern of violence repeating across generations. The judge's patience wears thin, and the defense looks shaky. It's not just contradiction. It's a legacy of damage. Unbelievable. How do you even defend this?
Well, that seems to be pretty clear, sir, since now you are charged with a third offense, domestic violence. And now here we have your daughter and your brother as victims. Who was the victim on the other matter? From last year, that you pled guilty on?
My ex-wife.
Would that be Layla's mom?
I'm sorry?
Would that be your daughter's mother?
Yeah.
Yes? Okay,
Yeah.
and the first one you had, sir, a couple years ago, who was the victim in that one?
That would have been the person that called this time. His wife, my brother's wife. Yeah.
Your sister-in-law.
Yeah.
So let's see, we have your ex-wife, your sister-in-law, and now your brother and your daughter that have all been victimized by you. And you're currently on probation for domestic violence second offense, who was the other victim in that matter? Because there were two charges and one was dismissed. So who was the other victim in that matter?
That one was with my ex-wife.
I understand that, but there must have been two victims because there were two charges. So who was the other victim?
She was the only one.
Did you have two charges? Was your daughter the other individual that was involved that time?
No.
No. It shows on his criminal history, 2 felony assault with dangerous weapons charges and 2 domestic violence charges, second offense. One of those was dismissed and both felonies were dismissed from town. So I'm trying to ascertain who the other individual would have been as the named complaining witness on that one.
Unless, Your Honor, it may have been charged 2 counts against the ex-wife, as well as the felonious assault or EFA charges.
Okay, well, here's, detective, as to bond recommendation.
Thank you, Your Honor. Unfortunately, I don't think the counseling and the drinking AA is working. I think it's more than reasonable for $5,000 cash bond each victim, so $10,000 cash. And if Mr. White posts, he is not to return. And he's to inform about his alternate living address, location, and contact number. Not to have any contact with the victims or witnesses in this matter. And not to have any additional cases, along with a GPS tether. Thank you, Your Honor.
Your Honor, we would ask for at least the opportunity to obtain a surety bond in this particular matter. I understand the $10,000, well, the total of $10,000 cash, but we'd ask that it also be cash and or surety.
You're asking for,
Rather, I'd ask for the 5,000, 10%, allowing him to post a total of $1,000, but the recommendation was for cash only. And I'm requesting that if the court will not make it a 10% bond.
The defense begged for leniency, asking for bond reduction. But the judge shuts it down hard. Instead of $10,000, he slams down a $100,000 cash bond. No discounts, no breaks. This ruling screams one thing: society must be protected first, especially his family.
And at least it would be cash or surety.
nope, no counsel. In fact, I'm considering not even allowing your client any bond. Given the fact that he's currently on bond, or on probation for domestic violence second offense. Now he has 2 counts of domestic violence, now he has a third offense notice, and he's also on probation in the 28th District Court. And in both courts that he's currently on probation for, he's not allowed to consume alcohol. yet he is. And now he's back here. And now we have his daughter as a victim. And now we have his brother as a victim. And so he poses a significant danger to society. And his family members, quite frankly. The court's going to order a $100,000 cash bond, no surety, no 10%. In the event you think that you would like to have treatment inpatient, sir, you can certainly request that to the Wayne County Jail. Thank you. Have a good day.
You judge, you too.
Thank you too.
The gavel falls, and the judgment is clear. Probation ignored, violence repeated, family endangered. A $100,000 bond ensures Zachary won't walk free easily. Justice here wasn't gentle. It was decisive. Stories like this remind us why courts hold such power. Like, comment, and subscribe for more unbelievable courtroom stories that leave jaws dropping.